going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great day so far. I've got a wow case for you. Judge Oakley. I still can't believe what I just saw. I really can't. And I don't want to spoil anything for you. I will let you know that the prosecutor kind of steps out of line. She gets called out by the defense attorney, then gets shut down by the judge. But that's not the wow part. You got to watch till the end. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Morning, Judge. Can you hear me okay?
I can.
Defense is ready.
People are ready, Your Honor.
All right. If you two put your names on the record for me, we'll get started.
Good morning, Your Honor. Sarah Bonoma on behalf of the people, P84189.
And good morning, Judge, to you and your staff, Robert Burton Harris, P81843, on behalf of Mr. Chris Peterson, who's present, zooming in from the Wayne County Jail, since this hearing being conducted on.
Thank you. And Mr. Peterson, can you hear everyone all right?
Not really.
Just give me. Not really? You want us louder?
A little louder.
All right, we'll try that. All right, counsel, I understand we've got two items up today, both from you. One is order of indigency, and the other is a bond reduction, correct?
Sorry about that, Judge. I was getting a call in. Yes, that's correct. It's two issues.
All right, well, let's take the indigency first, just because that happens to be on the top of my file. People have any position? I'm assuming you've seen the documentation, counsel?
Yes, Your Honor. I don't have any further information besides what he put in the motion, so I would have no position.
All right. So what you didn't tell me is any information so I could make a determination the guy's broke.
Well, I did include where he works, and I looked at my notes, and how much he makes per hour just escaped me, so that's why I didn't include it in my motion. I did indicate that, because Mr. Peterson is present, if you had any questions about how much money he actually had access to or made, he certainly can answer those questions for you directly. I don't believe that he makes more than $23 an hour, and I know that he was working part-time. So to the extent that he just can't afford investigators and experts in this case.
Okay. All right, Mr. Peterson, where do you work, sir?
Guardian Angel Care, which is my mother's company. That's a home health aid, helping elderly people.
I am, Your Honor, and I apologize. I'm having a lot of.
All right, Mr. Bickert, I'm in the middle of something else right now. I'm sorry, Mr. Peterson. Why do you work part-time?
Said I also work
Why
with my father.
Why are you working part-time?
Because I also work with my father. He owns a lawn service company.
So you have two part-time jobs?
Yes, sir.
Okay, and how much are you paid hourly on both jobs?
With Guardian Angel Care, I get paid $15 an hour. And the lawn service I don't get paid hourly, I just get paid at the end of the day. Actually, I get paid $15 from that too.
All right, and how many hours a week do you work between the two jobs?
I'm not
Are you averaging 40 hours a week, 50 hours a week? How much are you working?
Probably like 20.
Then go get a third job.
Yeah, about time.
How old are you?
24.
Are you healthy?
Say it again.
Are you healthy?
Healthy? Yes.
Then you should be working 70-hour weeks.
Can I add something for the court's indulgence, Judge?
Not unless you got a job for him.
Well, what I was going to say is that.
All right, we're starting off. typical Judge Oakley dad speech. You're 24. I worked 70 hours a week when I was 24. Yeah, we get that a lot from Judge Oakley. And yeah, I mean, I understand it. If he did work 70 hours a week, he probably wouldn't be in jail. He'd be too busy, which for him is probably a good thing. Anyways, yeah, prosecutor hasn't said anything yet. And remember, this defense attorney is decent. Prosecutor, I didn't think the prosecutor did a bad job. All right, I don't want to spoil anything. I'm talking too much. Let's go.
What Mr. Peterson is not including is sides with his younger sisters and a cousin who he also helps out with on a daily basis. So it's not that he's just, kind of sitting around not doing anything. It's just that he has other obligations as well.
He ain't working as hard as he should be, I can tell you that. I'll sign the order. Let's talk about the bond.
Appreciate that, Judge. So I think it's pretty clear from the motion. I kind of laid everything out. He's 24 years old, no criminal history whatsoever, never been in jail, never been in custody. This case is a prima facie case of self-defense to the extent that, that will be the defense. Frankly, Judge, I don't even know, and this is something I'm researching, I don't know to what extent the prosecutor is going to be even able to argue that the decedent in this case was not violent. And so the likelihood of conviction on this charge is extremely low, to say the least. As I put in my motion, he, like I said, has never been in jail. The Wayne County Jail is not staffed and not appropriately staffed, I should say, to be able to protect him long term. And so the magistrate who arraigned him, after I explained the circumstances of this case, felt that because initially his gut reaction was to just remand him because of the charge. After I explained the details of the case, he changed that so much that he didn't even order a tether for Mr. Peterson, but he still kept the bond at a $250,000 cash amount, which was just completely unaffordable. Mr. Peterson is obviously not working, or he's in jail. He doesn't make a lot of money to the extent that his family could afford to retain me. They don't have the money to pay a $250,000 bond. And so, Judge, I'm asking for a personal bond because there's really just no reason not to give him one. I think the best indicator of future behavior is past behavior. And this case, officers arrived. Mr. Peterson was sitting on the end of his driveway with a gun next to him that was made safe with his CPL and license on top of the gun. So he's clearly indicated that he's in no way, shape, or form a flight risk, and he's certainly no danger to the community based on what I said. Sister Counsel has sent me most of the discovery, I think, on their end so far. And so this was captured on video. You can see that what's on video supports what he told the officers to the extent that those statements are going to be admissible. So there's just really no reason to have him in jail other than the specific charge. But obviously that is not the only factor when you consider bond.
Thank you, counsel.
All right. Decent defense. Now, wait till the prosecutor starts talking. Now, if you were watching her during the defense's argument, she was smiling. It almost looks like she was holding back laughter. She is already questioning everything that this defense attorney's saying. All right, let's hear her side.
Response from the people.
Your Honor, just to start, so just briefly touching on the facts, we have ring camera of the victim parking across the street from his girlfriend's house or his ex-girlfriend's house, a couple houses down. We have the defendant, which is the defendant's mother. That's her boyfriend or ex-boyfriend, I'm not sure. We have the defendant who's trying to ask his mother, is that the victim? Is that the victim out there? But he can't get a hold of her. She's in the shower. That's when the defendant and his cousin calmly, casually walk across the street, armed with a gun. The victim exits his vehicle, goes to the passenger side to approach them because they have already approached him. There's some kind of conversation that took place, and then the defendant shot at least 7 times, if not more. There's no gun recovered off the deceased. The defendant doesn't say he had a gun when the police come. The cousin doesn't say he had a gun when the police come. They casually and calmly walk back across the street, all on ring camera, as the mother is hysterical. She's screaming, "Why would you do this?" He pulls up a lawn chair and he sits and waits for the police to come. I want to talk about the motion that defendant submit to the court. It says the shooting occurred at his home. No, it didn't. He was in the safety of his own home. He chose to leave the safety of his home and to confront the victim. He decided that in that moment, he's going to be judge, jury, and executioner. And then in the motion, it says the deceased has been abusing, stalking, threatening, harassing Mr. Peterson's mother, himself, and his family for years prior to the shooting. That's not self-defense then. He knows what he's doing. He went over to confront the deceased and he had a gun. He knew exactly what he was doing. The shortage of the Wayne County Jail is not permission for someone to get a personal bond. The fact that he's not familiar with jail, that's what the defendant's saying. I'm not familiar with jail and violent offenders, so I shouldn't have to sit in prison.
That is the first bond argument she's made. She is trying this case. Why would you bring up what he said about the deceased? You were trying this case. Why are you saying that for a bond argument? Sorry, I paused in the middle of her discussion. I'm a little bothered by it. It's going to come out.
The violent offender. The argument maybe can be made for someone on a CCW or a little possession charge. This is homicide second degree. I think $250,000 bond is way too low for a homicide. I am asking for a remand of the bond, and I'm asking for an exam. And after the exam, after the court has the opportunity to review the evidence, then we can address bond, Your Honor.
All right,
May I have a last word?
Mr. Burton Harris, anything else?
Yeah, so for a couple things. The defendant's statements support everything that's on the video, and I don't think the sister counsel said otherwise. I'm not sure how she said that.
Hold on. I lost your audio.
Can you hear me okay now?
Back way up. Back way up. You blanked out.
Okay, so I was just saying that I just want to address a couple things sister counsel said, and didn't say. The video supports exactly what he told the officers. I don't know how sister counsel knows what was said because she's correct. The Ring camera is from across the street, so you can't hear the conversation, but you see the my client backing up. You see the decedent coming at him and his 16-year-old cousin who was standing right there. So she's correct that it was across the street, and if I put it in my motion that it was at his house, that was just inartful on my part. But the shooting did occur across the street. So that's one thing. In terms of the reasons for confinement, sister counsel has flat out asked you to do something that's unconstitutional in the sense that she wants a high cash bond expressly so he can't get out. It's not connected to dangerousness. It's not connected to any type of flight risk whatsoever. In terms of what the mother said, I'm not exactly sure why that's relevant at all. I cited in my motion multiple police reports, multiple criminal court cases that were prosecuted by this prosecutor's office for the decedent. So the question about his dangerousness and whether or not my client has the right to go and speak to somebody because he has a CPL and carry a gun, I think Your Honor knows that is his protected right and that he can do that. The fact that the prosecutor has acknowledged and doesn't dispute this prior threat, stalking, et cetera, it honestly just kind of baffles me because the idea that my client has to stay in his house when there is a threat that has been ongoing and outside is not consistent with the law. And so if Your Honor is inclined to do some cash bond, his family cannot afford to pay more than $4,000. So I would ask that you would make a $40,000 cash or surety bond with a 10% provision so that they can post it. He can face these charges. He's already demonstrated he's not a flight risk. And in terms of him being in danger, I think we've already addressed that. And sister counsel hasn't said anything to dispute the circumstances of this shooting.
And Your Honor, if I can briefly.
Sure.
I guess the first thing is I'm not agreeing that there's been abusing and stalking and threatening. That's the defendant saying that. So how are you going to come back and say now it's self-defense if this has been going on? He knows what he's doing. He's also asking to drag the deceased through the mud about his criminal history, his past. And he's citing a 2005.
Counsel, let me stop you. I have to agree with defense counsel. I don't think you understand the purpose for which I set bond. You want to try the case today. Tell me why this individual is a danger to himself or others. Tell me why there's a danger that he won't show up. That's what I'm supposed to be determining today.
Okay, well, I
I'm not-
can't.
Boom. Judge, get her. I'm not saying she's saying anything wrong. She might be saying, 100% facts. I don't know. But this is, a bond motion. We're not trying to find him guilty today.
Trying a freaking case.
I understand, but I can't say that he's not going to show up because he doesn't have a criminal history. So I understand that. But he's charged with homicide second degree. And we can't just.
I read the file, counsel. I know what he's charged with. Tell me why he's a danger to himself or others.
Because he just killed someone and it's not self-defense. The other individual did not.
And you know that how?
Because the other individual did not have a gun. He even said to the police, the defendant said to the police.
You've told me all I need to know. You've told me all I need to know because obviously the only reason deadly force is justified is if the other person has a gun.
And what the defendant said. What the defendant said to the police and what his cousin
Your
said.
motion's granted, counsel. The bond is changed to $1 million personal. What's the next court date?
Thank you, Judge.
Oh, pick your draw up off the ground, prosecutor. I had to pick mine up when I originally heard this. I have never heard someone charged with homicide get a personal bond. Never. I sent a message to Judge Slavin and Judge Fleischer asking if they would ever even consider that. Is there any kind of circumstance that you would give that? Wow. So I guess the prosecutor messed up so bad the judge was just tired of it. Like, your motion's granted, personal bond. The defense wasn't even asking for a personal bond. The defense was asking for a $40,000 10% bond. It's set at $250,000 cash right now, which is, he's charged with homicide. Wow. All right, I'm gonna let this play out. You guys let me know how you feel in the comments. This is interesting. Let's just say that. Interesting. All right. Until next time. Bye.
I've heard your staff say that you were available for exams on August 28th. And our defense is free on that day as well.
28th of August, does that work for the people?
Yes, Your Honor.
And what time would this be, Judge?
How many witnesses do you think and how long do you think it's going to take us? Because I need to set it pick the scheduling.
I would probably anticipate at least 4 witnesses, Your Honor. And Your Honor, I'm sorry. I know you already made your ruling. Can I just mention one more thing just so the court?
No, because as you said, I've made my ruling. Now we're scheduling the exam.
Okay.
Defense, how many witnesses do you think?
I'm thinking 2. Can you hear me okay, Judge? Can you hear me okay, Judge?
I think it's 1. All right. Call it 1 p.m. on August 28th. Good day.
Thank you, Your Honor.
Thank you, Judge.